You should be looking at the PowerPoint again. Send me a chat if that's not true. Okay. Oh, all right. What are current interest rates? Well, they're darn close to zero, but just to keep the math easy, I like to say 1 year adjustable rates are now at 3%. I actually just closed the loan. Every time I refinance my house, I say that's the last time I'll ever refinance my house. And then I do it again a few years later. And I did just do it 6 or 8 months ago, and it was under 3%, but let's just say that's the going rate. How about credit cards? Credit cards are running 18% interest. If you think about it, both of these vendors are selling the same thing. They're letting you hold $1 for a year. How come this guy's got to charge you 6 times as much for the right to hold on to that $1 for a year? Some of you understand, you'll hear people say, and it's unfortunate it's not a live seminar for this reason, because I'd hear people calling out security, I'd hear people calling out collateral. All of that is correct. But why does that make such a difference? Why does that mean that the credit card guy's got to charge 6 times as much for providing the same product as the mortgage guy? Secured debt, the mortgage guy is secured debt. They have considerably less risk of a complete loss. Do borrowers ever default on mortgages? Absolutely, yes. And I can remember when everybody in the audience would say, no, that never happens. And then we had the prime loan scandal and recession of 2007 or 8, whenever it was. And there were a lot of defaults and a lot of foreclosures because lenders were lending to people that they shouldn't have been lending to. But if you think about it, and in that situation, the value of property was dropping precipitously. The subprime loan crisis had also pushed the value of real estate up much higher, speculatively high. So the value of real estate dropped, and it's still isn't back. It's been almost 15 years later, and real estate values are just now starting to get back to where they were right before the subprime defaults happened. Back then, values dropped to 75 or 80% of what they were worth just a couple months before, and debtors were defaulting largely for that reason. But even in that worst case scenario, that's the worst situation lenders have been in probably close to 100 years, or since the Great Depression anyway. They still ended up getting 50, 60, sometimes 70% of what they are owed. They would have legal fees. They would have to wait. They would lose money. They wouldn't get 100 cents back. But you think about what happened to the credit card guy in the same crisis. They lost everything because they had no security. And I'd like for you to think about the significance, the difference between recovering 50, 60, 70% of what you're owed as a worst case scenario and losing everything as a worst case scenario. The risk of complete loss is considerably higher for unsecured debt. That's the cost of doing business is higher if you are an unsecured lender, is another concept I want to drive home, and we're going to keep coming back to. But another part of this that people are quicker to forget is that the risk of default is also much higher with unsecured debt. I can remember when I was a bricklayer, I used to shuffle through my bills each month, and I always wanted to pay my bills, and I always did pay my bills eventually, but debtors prioritize their debt. And what's the first debt mom and dad are going to pay every month? Well, it's the mortgage, right? And that's partly because that lender is secured. You're going to have to pay that lender eventually, unless you're going to want to move out. That lender's going to charge you late fees. That lender's going to charge you default rates. They're going to make you pay eventually. You might as well just pay now. What is the last debt mom and dad are going to pay each month? And people often at this point, since I've set you up, people at this point will be calling out the credit card debt. And I'd say wrong. That's not correct. The credit card debt is not the last debt you're going to pay, because you signed a very detailed credit agreement with that credit card lender. They're going to charge you a late $50 late fee anytime you're late, and they're going to make you pay it. And they're going to charge you a default rate on the credit card. It might be 24% or even more. And they're going to charge you. You're not going to talk them into taking it off of there. And those penalties are enough to motivate you to get them paid. At least make that minimum payment. And that's where they're really making their money. Of course, when you're making just minimum payments and they're charging you 18% to hold the money. What is the last debt mom and dad are going to pay? It's the doctor. I've had the same doctor for 35 years. He's very important to me. I want him to keep taking care of me, but he's the last debt I'm going to pay, because he never even made me sign a credit agreement. At most, I'm going to have to pay him 6%, a legal rate of interest if I'm late. And as a matter of fact, as long as I pay within 90 or 120 days, he's not even going to charge me that. I never agreed to pay his legal fees. That's the cheapest place for me to risk a default. So that's the last debt I'm going to pay. So what I'm trying to get you guys to focus on, and I'm sure most of you have it already, is the risk of default, the risk you stand of having a debtor default, incurring legal fees, having to wait for your money, comes from two places: whether or not you have security or collateral, and whether or not you have contract terms that constitute penalties to the debtor for failing to pay you. All right, what if the rate for all lending was 10%? Some extreme liberals might be of the view that it's not fair, it's un-American that homeowners can borrow money at 3%, but if you don't own a home, you have to pay 18%. That's unfair, it's un-American. Let's pass a law that all lending's got to be at 10%. Who's going to like that? Who isn't going to like that? Well, the secured lender is going to love that. As a matter of fact, it was probably their lobbyist that was getting that bill passed. They used to only be able to charge 3%. Competitive forces held them to 3%. And now they can just charge 3 times as much with the same amount of risk. They're going to be getting rich. But what's that going to do to the credit card lender? It'll put them out of business. A credit card lender really needs 18% because their cost of doing business is higher. Their risk of default is higher, and their risk of a complete loss is higher than the mortgage lender. Went going the wrong way. What if the rate for all lending is 0%? How's that going to work out? And at this point, a few people in the audience are going to be saying, well, nobody would lend any money. Nobody would lend any money. And maybe some of you guys have fallen into that trap already. As you can see, I like to set traps. That is the rate you lend at every day. You send hundreds of thousands of dollars out the door on a daily basis, and that 0% is the interest rate you charge. You are hopeful that you will be paid in 30 days and get paid 0% interest. And if you get paid within 30 days, you're thrilled. You feel like a hero. Your boss is happy. Everybody's happy. And you got 0% interest for that. If a debtor goes 60 or 90 days without paying you, and then they send you a check for principal only, are you going to demand that they pay back service charges? Depends on who it is, depends on how important they are, depends on how often they do that, but probably not. You're probably not going to charge. They just wrote themselves a loan for 90, 120 days and they paid 0% interest. What if you have a customer, and I guess really a GC or a supplier. You have a customer who hadn't paid you for 5 or 6 months. And after 5 or 6 months, they call you and they say, okay, I've got some money. I got to decide where I'm going to send it. And so here's the deal I want to make. I'll send you 100 cents on a dollar if you just agree to waive all interest and all legal fees. Are you going to take that deal? I mean, it depends on who it is, et cetera. But you're probably going to, and you're probably going to be very relieved to have been able to do that. 0% is the rate you are charging. All right, let's think about what happened the last time you bought a house. So anyway, the point is, if you're not really able to charge 18% like an unsecured credit card lender, you don't have the same opportunity to get back the risk of loss, to get back on the deals where you just plain lose money and you don't ever collect. You've got to go do, if you have one complete loss, you've got to go do 7, 8, 10 completely flawless transactions just to be even. And you have to do more deals than that to be making money again. You're rarely able to charge your debtor to get those losses back. You just have to do more transactions, find more buyers is the point. So in other words, your cost of doing business is higher. Your risk is higher than even a credit card lender. And your risk of taking those kind of losses is going to depend on contract terms you have and the security you have. All right, and this is jumping ahead to the mechanics liens and payment bonds that we're going to talk about on March the 9th. But it all fits together, as you can see. So we're going to start talking about it now. Ooh, we got 24 people now. That's good. And everybody, if you want to send me a chat with a question, I haven't seen any yet, but I may defer questions if I know it's something I'm going to deal with later in another half hour or 15 minutes. I won't answer. And I prefer to take questions that are fitting right with what I'm talking about right now. But if you're just plain confused about something, I'd like to try to answer your question now. I will also hang out for an indefinite period of time when this seminar is over, if anybody has any questions. All right, let's think about what happened the last time you bought a house. You signed 2 sheets of paper. One was the promissory note. That's the sheet of paper that says, if you give me $100,000 today, I will give you $1,000 a month for the next 30 years. It probably also says things like, if I fail to send you my $1,000 a month, I'll pay a late fee of some percentage of the late payment, pay legal fees. There might be a default rate of interest. As we'll get to in a moment, a promissory note is a type of contract. That's exactly what it is. But it is signed by the contract debtor. And these are all terms I'm going to be using all day. So I want to introduce you to those terms. This is your contract. It is signed by the contract debtor. It allows the creditor to sue the debtor and obtain a judgment. That's what a contract gets for you. This is an unsecured promise to pay. Those are terms I'm going to be using throughout the day. Unsecured promise to pay, the only thing it gets you is it allows you to sue the debtor. And if you succeed in getting service and you succeed in convincing a judge that you're owed the money, the judge will give you a judgment. And that judgment gives you the aid of the courts, is the terminology. Now the courts will let you use the garnishment procedures or the levy procedures and various procedures to enforce a judgment and collect your money. That is chapter 17 of the book, enforcements of judgments. You didn't have mechanics lien rights, you didn't have payment bond rights, but all you had was a contract. That's what we call straight collections. There's no security rights involved, straight collections. And we do a lot of that too, and you guys get stuck with unsecured debt once in a while. That is what chapter 17 is about. If the debtor doesn't have any assets, there's nothing to attach your judgment to, you will be unable to collect. You have an uncollectible judgment, which is your worst case scenario. All right, last time you bought a house, there was another sheet of paper you signed. This sheet of paper described a specific piece of property, and it was signed by the owner of the property who, in this case, in a residential scenario, it's the same person. The contract debtor also owns the house, but that isn't always so in commercial transactions. But this sheet of paper has to be signed by the property owner because that's the only one who can grant security rights in their property. This sheet of paper says that if contract debtor defaults, the lender can foreclose upon the security property or the collateral. And this particular lender has first dibs on this particular piece of property to sell it. And they get to keep all the proceeds until they've been paid in full. The lender does. Okay, so the promissory note is a type of contract. What's a mechanics lien? It is remarkably similar to a mortgage. People are often surprised to find out how similar they are. What's the difference between a mortgage and a mechanics lien? Well, the main difference really is in a mortgage case, and I rarely foreclose on mortgages, but there are other lawyers that's what they do. They work for banks and such. And they rarely end up in an argument about whether or not there is a lien on the real estate. It's possible, but it's unusual. Perhaps if there was a forgery on the deed of trust or the mortgage or something, but that's very rare. In mortgage litigation, the main issues are usually the value of the property, whether there is sufficient collateral to cover the debt, and how many different lien holders they are. Are you first mortgage or second mortgage or third mortgage? But you're not arguing about whether you have a lien. That is admitted usually. The main difference with mechanics lien litigation is you are almost always arguing about whether or not you have a lien. Did you file the sheet of paper within 90 days of your last work? Did you violate the 150-day rule? All of these arcane rules that we're going to talk about on March the 9th. If it's true mechanics lien litigation, the property owner, the lender, the bank, they are disputing whether you have a lien or not. That is because you are engaged in a battle between innocents. and that another theme we're going to come back to time and time again. And we'll get back to this repeatedly, but why is mechanics lien litigation so complicated? The answer is because it's a battle between innocents. 90% of the time, 90% of the mechanics liens we file our lien, the phone rings, somebody wants to make a deal and send you the money. That happens time and time again, and maybe you've had that experience. You think I'm a hero, you think I'm a genius because I just, charge you less than $1,000, file this mechanics lien. The check arrives in the mail, the phone rings, the check arrives, case is over with in a month. And then on that 10th case, all of a sudden, I say, well, the phone didn't ring. You're going to have to enforce your mechanics lien. I'm going to charge you another $1,000 to enforce your mechanics lien. And we do that. And then we get into discovery, and the bank is filing a paper reciting the 20 things that are wrong with my mechanics lien. And you might be wondering, well, did Fullerton must have screwed this mechanics lien up? Usually the phone rings and somebody just sends me a check. Well, you finally run into genuine, real mechanics lien litigation. That is what is happening. It is a battle between innocents. If the owner's holding enough money on the GC to cover the amount owed by all the suppliers, you're never going to be arguing about whether you filed your mechanics lien on time you're not going to be arguing about whether or not you have a lien. The owner and the bank would rather the subs and suppliers that deserve the money, that have the contract rights, they'd rather see them get paid. And as long as there's enough money to do that, that's what's going to happen. If the bank has to foreclose on the real estate, and now you got 3 or 4 mechanics lien claimants trying to make the new owner, the bank, pay for the brickwork and the site work and the paving, the bank's going to tell their lawyers, we already lost money on this mortgage. We don't want to pay for that paving. We already gave the owner draws on the construction loan to pay those guys. We already paid for that paving. We don't want to pay for it again. Do what you need to get rid of that mechanics lien. And I do mostly plaintiff work, but I do defense work sometimes too. And, a defense lawyer on a mechanics lien case is going to be very competent, and they're going to come up with 20 good arguments about why this mechanics lien's invalid. And they're going to file them, and we're going to argue about it. And that's the way it is. That's real mechanics lien litigation is a concept we're going to keep getting back to. All right. So mechanics lien is not granted by the property owner. It's granted by the legislature. And there are a list of rules you have to follow. We're going to be talking about those a lot on March the 9th. And if you fail to follow all the rules, you're not going to have a valid lien. Now, what's the third thing that you guys have in your business sometimes? And people call it security, but as we'll see, I don't view it as security. Sometimes suppliers require a personal guarantee. So a supplier might have a contract, they have a credit agreement or some other type of contract. They have their mechanics lien rights as security. They may also have a personal guarantee on the president of the subcontractor corporation who is purchasing the material from them. Now, I want you to notice, sometimes people call this security, and I have a lot of supplier clients. And I say, well, do you have any security? And they say, well, I got a personal guarantee. And I go, yeah, okay, good. And I know what they mean. I don't usually say, but I can say now. That's why one reason I like teaching these seminars, I can say things that won't annoy you as much as when if we're having a conversation just about your particular case at another time. it's not actually security, as part of the point I want to make. The significance of a personal guarantee is that it is signed by a different debtor. Now you got two different people you can sign. It works just like this contract over here, the promissory note or the credit application or the proposal, the quote, that here you can sign, you can sue the corporate debtor, the subcontractor, comma, Inc. With this personal guarantee, you can also sue the president individually and perhaps the president's husband also. And so you have a better chance of collecting your money. However, if the subcontractor Inc. becomes insolvent and goes into bankruptcy, there's a good chance the president will also file bankruptcy. As a matter of fact, it often occurs that the debtor won't even bother wasting a bankruptcy filing fee for the subcontractor corporation. They'll just close business, change bank accounts, reopen a new business with a very similar name at the same address with the same phone number. But the president who owned all the stock in that old corporation and who's going to own all the stock in the new corporation, they're going to file bankruptcy because they want their clean bill of health. And so it's worth a filing fee and they will do it. And that's the way it works. And I don't want to hear any whining and crying about, this guy closed his business and reopened a new one. You just need to understand, if the people you're doing business with, if their last name is LLC or Inc. or Corp, that's the deal. That's the deal. That as long as this business stays in business, you will get paid. If this business fails and becomes insolvent, I will lose everything, all of the assets in that business, but you're not going to touch me personally. That's the deal. If you're not satisfied with that deal, you have to ask for a personal guarantee or get security. Get it? All right. What is a payment bond? It's one of these. So I'm really jumping ahead. That's the last thing we'll talk about on March the 9th is payment bonds. For our purposes now, I want to explain that a payment bond, it really is a type of guarantee. That's what it is. The difference between a guarantee and a bond is that the debtor, the second debtor that signed, is usually a big insurance company, and they're very unlikely to file bankruptcy like the president of Subcontract Inc. might. However, as we'll discuss on March the 9th, bonding companies do become insolvent sometimes. And the financial strength of the bonding company is very relevant. And you do need to be aware whether this is a strong bonding company you're relying on or a weak bonding company. And we will talk about that at length on the 9th, but I'll just mention it now. Okay. Oh, and this is also jumping ahead, but the bond is signed by the bonding company and a bonding principal. Gregory, if you weren't aware of it already, when Shirley provides a payment bond on a project, the bonding company is on the hook to the suppliers, but Shirley is also. There are two signatories to every bond, the principal and the bonding company. They are jointly and severally liable on the bond. All right. Now, we're going to swing back to contract terms for the rest of the day. I mean, we might mention security now and again, but we're going to mostly talk about contract terms the rest of the day. And we've figured out the significance of contract terms is that it lowers your risk of default and it increases your chances of recovering legal fees, interest, carrying costs, and other costs of default. In other words, another way of putting the same thing, and the word I normally use, is contract terms provide you leverage. It motivates the debtor to pay. It helps make sure you are not the last debt that gets paid. All closely related concepts. Contract terms will not prevent all your problems. If you do business with the wrong people, you will have problems. I always am struck when a client, and this happens at least 2 or 3 times a year, a client, it's usually a new guy, a new client, because they know they learn otherwise after a while. But a new client will come in and they'll hand me a 15-page contract that somebody's given them. And they say, well, I want you to review this to make sure I don't have any problems. That always kills me. And I always say, and you guys may have heard me say, that's an impossible job description. If this person you're doing business with is going to become insolvent, you're going to have problems. There's nothing I can put on this sheet of paper that is going to avoid that. If this person you're doing business with is dishonest, you are going to have problems. There's nothing I can put in this sheet of paper that's going to change that. So, do contract terms matter? I've also heard a lot of clients say, and this is something subs will often say, oh man, GC isn't going to agree to change their contract at all, which we'll get back to repeatedly today, because I don't think that's quite true. And usually the contract's just signed and put in the file and nobody ever looks at it again. I agree with that. And that's what you hope happens. So I can't argue with you. If you feel as a business matter that you don't want to spend a plug nickel on legal fees reviewing contracts, I'd rather save that money and just put the contract in the file. And if there's a problem, then I got to call Fullerton to deal with it. But if there's no problem, look at all the legal fees I saved. I can't argue with that. That's a business decision. I am not telling you it is always a better idea to have us review every contract that you get. I'm not trying to tell you that, but I do want you to focus on the fact that the contract terms do matter. They are about leverage, cost, and risk. Is there a penalty you can make the debtor pay for defaulting or paying you late? Do you have a way of getting your costs back, your cost of carrying money, your legal fees, and your risk of default? As we talked about early, contract terms lower the risk that the debtor is going to default on you. I think the best example of that is an attorney's fees and service charge clause. You want it in every contract that you ever write. And people will often think I'm saying that just because I'm a lawyer. And yes, I am a lawyer. And yes, I am fully in favor of legal fees. I've never understood why you guys don't like legal fees. So yes, I like legal fees, but that's not why I'm saying this is the most important term in your contract. This is your greatest source of leverage on the debtor. To put the same, it will work me out of a job, is what I'm saying. It will make it far less likely you'll need to hire me if you have this. If you do not have a legal fee provision in your contract, the debtor, and just like when I was a bricklayer, they've got all these debts they need to pay and they're prioritizing them, what order they need to pay them in. And believe me, debtors know. They know which projects are bonded. I better get that guy paid on that project, because if they make a bond claim, it's going to make Shirley very angry, and it's going to make them give me trouble on this project and other projects. I know that supplier made me sign a credit agreement that I got to pay legal fees and 18% interest, and I know they're going to make me pay. I better pay them. But here, look at this other contract. This guy didn't even have a legal. They just sent a proposal, and this is what a lot of you guys do. It just describes the scope, describes the plans and specs, has exclusions. This contract does not include the following items. That's all. You guys are all great about doing that. There isn't a single legal term on the proposal. You missed an opportunity to control the contract documents, and now you're missing the leverage that you need to motivate that debtor to pay you. They decide, this is what really happens. They decide you're the last debt that's going to get paid because they can pay you $100,000 today, or they can make you wait a year until you're on the courthouse steps. And the most they're ever going to have to pay is that same $100,000. And you'll probably take 70 or 80 cents on the dollar to have it over with. That's the debt. But if you had the ability to make them pay legal fees, and these are the words I often speak, and you want to make sure you can speak the words, listen, you can pay me that $100,000 now, or you can pay me $150,000 later. That's up to you. But I think you would be well served to just make sure I get paid, because it's going to lower your cost of doing business, debtor, and we can remain friends and continue doing business, because we will sue you and we will insist that our legal fees get paid. All right, so that's leverage, motivating a debtor to pay, cost, and risk. All these other terms are the same way. Now here, let me see a new share. Let's see if I can get this. All right, share. Ooh, boy. So you could, if you wanted to, I don't care whether you do or not, but all of these terms I'm discussing are on this 1 8.5 by 11 sheet of paper. This is your attorney's fee and service charge term here, paragraph 6. You pay a late charge of $20, 1.5% interest per month. Judges will generally enforce that. And attorney's fees equal to 33% of any balance due. Okay, that's where that is. Now let me see if I can figure out new share. We want to go back to the PowerPoint. Go. Ooh, I'm feeling quite technologically competent. Okay, oh, well here, it's in the PowerPoint anyway. This can come in the form of a credit agreement. The page 1 is all the information about the debtor. Page 2 are the terms. A proposal for labor and materials is the same way. But what I'm suggesting to you is that if every bid that you ever do, you want to be careful about making sure you're identifying the correct plans and specs, you're identifying the correct scope, you're identifying the correct schedule, you're identifying, these are all the business terms on page 1, but you have an opportunity to control the contract documents. Make sure you make use of that opportunity by having a page 2, having a flip side on that bid, on that proposal, with the 1 8.5 by 11 sheet that you're welcome to download off, copy and paste off of our website. And I know a lot of people do that, and I couldn't be happier. Just remember where you got it if you ever do need help on something else later. But I like the fact that people use these and help themselves. And I don't miss that opportunity. This might end up being your contract. Sometimes more, and maybe it's only 10% of the time, but it happens more often than you might think. You will receive that proposal or that quote in the mail signed. You have a contract. And you could end up very sorry if you miss the opportunity to get these legal terms. The other thing you're going to do, or excuse me, let me say, another thing that might happen is that the debtor just calls you and says, get your rear end out here. You know, we got to start this project. And if no other document is ever presented to you and it's not signed, I think you have a very good argument that this 2-page proposal that you sent is the contract. You will probably win that. Maybe that's a 60-40, 70-30 probably win, but you will probably win that. If I'm the judge, I sent you a contract, you said, get your rear end out here, that's an acceptance of the contract, especially if there's an email or something where you will probably win that. The third thing you're going to do, as we're going to be talking about in a little while, when even if the GC or the owner sends you a contract to review and sign, you want to incorporate your proposal or your bid or your quote by reference. Attach it as an exhibit to your contract, or just say in the contract, my bid of this date, February 22nd, 2021, is incorporated herein by reference. That's enough that this 1 page and your exclusions and your scope on the previous page are a part of this contract. Now, when I'm doing seminars for general contractors, I tell them to be very careful about this, because that subcontractor is successfully changing the terms of the contract, and you don't want to let them do that. But as a creditor, as a supplier or a subcontractor, I'm telling you, you want to do that on every project that you are bidding on. And you do want to incorporate it and make it part of your contract. And a GC wants to do that with the owner. Sometimes you're a debtor, sometimes you're a creditor. Okay, supplier proposal or order acknowledgements, the same way. This second page is very similar to the second page of the credit app and of the labor and materials proposal. Okay, what are some other leverage terms? One of the paragraphs on that 8.5 by 11 sheet of paper is a forum selection clause. Customer expressly agrees to submit to personal jurisdiction. The forum for any litigation shall be County of Fairfax, Virginia. This agreement shall be governed by and construed in accordance with the laws of Virginia. Now that sounds very lawyerish, and it is, but again, it will make a difference in your real life. It has an impact on your cost and your risk in any dispute. This tells you how far you're going to have to drive to go to court, whether you're going to be able to use your regular lawyer to litigate a case for you, or whether you're going to have to hire a lawyer somewhere else. To put the same thing another way, when you're reviewing contracts people send you, as we'll be talking about later, and you receive a contract that says any litigation about this contract shall be in Wilmington, Delaware, which is a common choice, or it might even say California or whatever, that is really going to increase your costs in any dispute. If you face the choice of either hiring a lawyer in Wilmington, Delaware that you've never worked with before and you don't even know them, or paying me to drive to Wilmington, Delaware every time there's a court appearance, neither one of those choices are good for you. So you need to pick that up and change that in any contract that you are reviewing. And as a matter of fact, Virginia and Maryland, not DC, but Virginia and Maryland, both have venue statutes that if there is a dispute regarding a construction project in Virginia or in Maryland, a contract provision that forces litigation outside the state is not enforceable. However, just to spin you all the way in a complete circle, and I'm sorry, but this is one place that I have to do this. The arbitration provision, federal law really just loves arbitration, and I'm not a big fan of arbitration, as we'll probably talk about repeatedly. And this is one of the things I don't like about it. The Federal Arbitration Act says that an arbitration provision trumps all other laws, state laws, trumps all other policies, trumps all other contract terms, which I don't like. And one of the reasons I don't like it is it means that if you make the mistake of signing a contract that says in the event of any dispute, you shall arbitrate this dispute in California, that is going to be enforceable, even if the dispute regards a construction contract in Virginia, where all the witnesses are in Virginia, all of the contractors. The only one that's not in Virginia is the California owner, is what it comes down to, and maybe the bank. But the GC, the subs, the suppliers are all in Virginia, and they're all going to be flying to California. That is the issue of forum. It matters. It's a matter of cost. If you have to go arbitrate this case in California, that's a case you're going to sell cheap, because you don't want to spend your life on airplanes. You don't want to hire a lawyer in California. You have a problem. You've got to sell the case cheap. And the bank or the owner who has a big incentive to force you to dispute it, and they're in a better position to avoid paying you. Now, I want to point out a couple of other bells and whistles here. What we've been talking about is forum selection clause. There's a couple of other features here. See, this last sentence says, this agreement shall be governed by and construed in accordance with the laws of Virginia. A lot of people make the mistake of thinking that says the forum for any litigation will be Virginia. It does not say that. And if the debtor files suit, or if the opposing party files suit in California or Maryland or whatever it is, and you say, but wait a minute, this agreement says it should be governed by and construed in accordance with the laws of Virginia, the judge in California is going to say, well, yes, it does. And unfortunately, I'm going to have to bone up on Virginia law in order to decide how to interpret this contract. So it is governed by, that is a choice of law provision. That's different than a forum selection clause that says you're going to be standing in Virginia in an arbitration or in litigation while you are construing that contract in accordance with the laws of Virginia. The very first part of this is talking about jurisdiction, which is really kind of lawyerish, and it's not usually an issue for you, but I do want to point out it's different than choice of law. It's different than forum. Jurisdiction has to do with whether the court in Maryland can force you to go to Maryland and answer a lawsuit filed in Maryland. This is not usually an issue, because if a contract was negotiated in Maryland, Maryland has jurisdiction even if the construction project was in Virginia. So the only way you're going to have a jurisdiction issue is if there's really no connection. Even the California case we've been talking about, if the owner, their office is in California, and you had a couple phone calls with, or somebody did, the GC had a couple phone calls with the owner in California negotiating this contract, that's sufficient minimum contacts that California does have jurisdiction. Breach. Okay, so a creditor, a GC wants this, a supplier wants this, seller or creditor shall have no obligation to begin or continue performance until adequate credit or funding information is provided on request of seller. That is critically important. A lot of people are surprised to find out that that term is in most AIA contracts. In other words, it is a patently reasonable term. It is in the 8.5, and these appendix numbers down here, it's in Appendix 1, which is the credit app. It's in the Appendix 5, which is the labor and materials proposal. It's in the Appendix 6, which is the supplier quote. I should have pointed that out before. This term is in all three of those, and that's a place you could get the, well, here's the wording right here. You don't need any more than that. A similar term says that you may stop supplying labor and materials when payments stop until payment is made or any other dispute has been resolved. This has some similarity, but some differences too. This seller shall have no obligation to begin or continue performance. That's a matter. Does the customer have the money? Does the debtor have the money? This becomes most important in the case of change orders, delays, defects in the plans and specs. There's problems on this project. The costs of completing this project is going up. Does anybody have the money to pay for that? The cost just went up $1 million because there was a 180 day delay on this project. Where's that $1 million coming from? You need to put yourself in a position that you're allowed to ask that question. Similarly, if you hear rumors, somebody may have financial troubles or whatever, you may want to say, show me the money. A supplier might want to say, show me the money, or I'm not delivering. The second term is a little bit different, and it really deals with a situation that you're not getting paid. The debtor is now 60, 90 days past due. Got the quotes on that. You're telling me they're past due. And I will regularly have clients on the phone saying that, our contract says 30 days on invoice. They haven't paid us for the last couple of months. I'm going to quit work. I'm going to stop work. I don't have to work out there anymore, do I? And I can tell you, I am almost always going to say, no, you need to keep continuing performance. The risks are too great otherwise. And again, one reason I like doing seminars like this is that's really going to irritate you when I tell you that. And you feel like the debtor is in default and not paying you. But the reason I'm going to say that is multiple related reasons. The most important is that there's a huge divergence in a difference in damage because of default. In other words, what a lot of people don't understand is it's quite possible, and indeed in construction, it's probable that both parties, everybody is in breach of contract from day one. In other words, I don't think any construction project in history has ever been built exactly according to schedule or exactly according to plans and specs. And I'm not sure there's ever been a project in history that payments were exactly on time. Everybody is in default to some extent on every construction contract they ever sign. And usually the contract's signed, it goes in the file drawer, and you just never talk about it until there is a dispute. Everybody just gets along, but both sides are in default. And if you walk off that job, what's going to happen or the risk at least of what's going to happen, is that you'll hire me, God bless you, we'll file suit, and after all that happens, the owner or the GC, whoever you're in a dispute with, is going to file a legal pleading listing the 35 different ways that you were in breach of contract at the time that they stopped paying you. And guess what? They're going to make some of them stick. Or at least you're going to have a big problem defending it. You were probably in some kind of minor default from day one on the project, and they're going to at least be able to make noise about it. And here's your real problem: the difference in the damages. If the debtor was in default for failing to pay you, and they really were supposed to pay you 30 days on invoice, and they didn't pay you for 60, 90 days or a year, what's your damage? Legal rate of interest, 6% per annum on $1 million, $6,000 in damage if they held $1 million on you, $600 in damage if they were holding $100,000 on you for a year. Yeah, you're entitled to those damages. If you delayed the project by 6 or 12 months because you walked off and it took them that long to find a replacement contractor to finish, and it turns out you were in default or that both of you were in default, what's the owner's damages? What's the GC's damages if that project was delayed 90, 180 days? Their damages are huge, a lot more than carrying cost of money. And it's that difference in damage that you can't take a risk on. You must continue performance and that will lower the damage to all parties, lower the damage to everybody. I'll file suit. We'll file a mechanics lien. We'll make your payment bond claim, but you're going to continue work is almost always going to be my advice. Go. All right. Notice and an opportunity to cure. On Appendix 1, 5, and 6, the term you want in a contract that you are writing will say, you're going to look at my work very carefully at the time I give it to you, or my materials, whatever. And you have to give written notice specifying any claim within 10 days, or you're waiving any claims for defects in the material after that. Now, there's no question suppliers want that in their terms. Most of my clients that are suppliers have that in their terms, but there's no question the buyer, the debtor, doesn't want that. They at least want more than 10 days. So that's, just another place there's tension. But the creditor, and I'm usually representing the creditor, there's no question you want this in every contract that you write. Now, this is related, it's similar. I think it's even more important. And these are all three together on the forms on our website or in our book. Seller will not be liable for any damage, warranty, or remedy. Back charges will not be accepted unless you give us written notification specifying the defect in my labor and materials. I have an opportunity to view it and repair it. And you cannot back charge me your costs, your completion costs, or your costs of correcting defects unless you have given me written notice specifying the defect. You let me look at it, you give me a chance to fix it. Now, if I am a judge, that is a patently reasonable term, and I am going to enforce that. Judges will enforce that. And if you won't be surprised to find out that is critically important, because otherwise the risk you're going to run into is something we were mentioning a few moments ago. Otherwise, when you eventually file suit and trying to collect your money, the debtor's going to respond with the list of the 35 things you did wrong on the project. And you're going to be telling me, wait a minute, that's the first I've ever heard any of that. They never gave us any notice of that. Well, we might get some mileage out of that. We might be able to make that argument. It kind of depends on what the owner's evidence is. Maybe you got some notice you weren't aware of, or they're talking to somebody on the job. But if this term was in your contract and the notice has to be written, and the notice has to specify, you see that's underlined. The important part of both these terms is that it's written notice and the notice must specify any claim, then you're not liable for it. In other words, what I'm thinking there, I have cases all the time that I'm receiving letters. In fact, I got a case right now that's for $1 million, and this is exactly what happened. The owner kept sending letters. You're in default. You gotta speed up performance and get out there and fix that, without ever specifying exactly what the problem was. And we were eventually terminated. And yep, sure enough, now they're giving us plenty of detail on all the things we did wrong. And we have a problem. I'm not saying we're going to automatically lose. Hope not. I hope it's a problem for the owner that they never specified any defects until they got to litigation. But if the owner can really show we did something wrong and the owner can show they really were damaged, we're going to have a problem. If we had this term in our contract, perhaps not. All right, let's talk about the trust fund. Let's see, where? All right. Sorry. All right. Maryland has a trust fund statute. I'll give you the short version on how that works. In a way, this belongs with the mechanics lien and bond lecture that we're going to do March the 9th. But it is also, you can put trust fund provisions in your contract, which is what we're going to talk about now. But I'll go ahead and give you a preview of March the 9th. Maryland has a trust fund statute. As a matter of fact, right now, they're working on one in Virginia, FYI. You may not have heard that. I'm a big believer in trust fund contract provisions and trust fund statutes because it helps everybody. We'll get back to that in a minute. Here's how it works. Suppliers supply materials to the sub. The sub supplies labor and materials to the GC. The GC collects labor and materials from multiple subs and provides it to the owner in the form of a completed project. You guys have heard that story before. Now what happens? The money flows down in the opposite direction. The owner pays the GC. What the trust fund statute says, the Maryland trust fund statute says, is that when the owner pays the GC holds that money as trustee for the benefit of the subs and suppliers on the project. And then when the GC pays the sub holds those funds as trustees for their subs or suppliers. That's what the trust fund statute says. Why does that matter? It matters a lot, and it's important to me that you guys understand this. You can sue, if you don't get paid, you can sue the trustee for breach of trust. It's similar to breach of contract. you can sue the trustee for breach of trust. But if you think about it, that isn't really adding all that much to this provision, because you could have sued him for breach of contract. You might be able to circumvent your contract debtor. A supplier might be able to sue a GC for breach of trust. I guess that adds something, but it's not that much different. Doesn't add that much over a breach of contract. So why is a trust fund statute so important? I like to use the example of my wills, because it used to be a true story that my wife and I have sweetheart wills, and that means her will says that if she passes away, I get everything, and my will says, if I pass away, she gets everything. And then the second one, if we both go together, or when the second one of us dies, everything goes into a trust for the benefit of our children. And the trustee of that trust are to use that money for the health, benefit, and welfare of my children, and send them to college. And let's say my wife and I both go down in a plane crash, and our kids were still little. That's why this isn't a true story anymore. My kids are in their 30s, but I still have trusts. But let's say this happened when they were little. My brother was trustee. That was a true story. And so my kids move over to his house, and my brother has all our money, and he opens a bank account for the trust, and he takes the money to pay part of his mortgage every month. He takes the money to take my kids on vacation. He takes the money to send my kids to private school. He can write checks on that bank account anytime he wants. Let's say my brother's in the construction business, and he gets on some bad projects and does business with the wrong people. He didn't do anything wrong, but now he's insolvent. Now he's bankrupt, lost a lot of money. So all of his creditors, all his suppliers, let's say, got burned for a lot of money. And the way suppliers always look at it is, this is grossly unfair. This guy bought all this stuff and he didn't pay for any of it. Look, he's got a lot of money. Let's garnish that trust account that he has. He writes checks on it all the time. He's the only signator on that trust account. Is my brother's creditors going to be able to garnish the trust bank account? Answer, no. Usually I have an audience that you'll be out there yelling no. But tell me why not? Why not? What's the legal concept? It's not his money. It's not my brother's money. It's not the trustee's money. The money always belonged to my children. The trustee, my brother, held mere legal title. And in a trust fund statute, like the Maryland Trust Fund statute, the same is true. When the owner pays the GC holds the funds in trust, and for the benefit of the subs and suppliers. Where is that important? For example, it's one of the few protections you have in Maryland if your debtor files bankruptcy. As we'll learn March 9th, bankruptcy will usually cut off your mechanics lien rights in Maryland, but it does not cut off your trust fund statute rights. And if your customer files bankruptcy tomorrow, you as a sub or you as a supplier are going to have the ability to say that money in the GC's bank account are funds the GC held in trust for my benefit. It's not the GC's money, it's my money. And that works in real life. In other words, let's say the GC files bankruptcy. real early, the GC saying, bankruptcy court, I want the right to use my bank account for payroll. If I can't use the bank account for payroll, I'm going to have to go out of business, and that's bad for the general unsecured creditors. The bank's saying, wait a minute, we have a security interest on all these bank accounts. And if he uses it to continue in business, it puts our security at risk. And this is almost always the first big issue in every corporate construction contractor bankruptcy. And what happens in real life, FYI, we'll have to decide whether to do seminars on bankruptcy also. But what happens in real life is they make a deal, and the court will agree that the bank gets a super priority interest in all of the accounts receivable. They have absolute first dibs on all of the accounts receivable and the other assets of the debtor if they agree that the debtor can use that bank account for payroll. And one thing we'll learn on March the 9th, if you have mechanics lien rights, you are one of the very few guys that are going to burrow ahead of that super priority security interest that the bank has. But anyway, back to the trust fund, they're in court in the first couple of days of the bankruptcy arguing about how they're going to make payroll this Friday. And if the trust fund statute applied, you as a supplier or me as your lawyer can go to court and say, wait a minute. These guys are having a conversation about this bank account, and I'm sorry about this payroll thing. And, the bank's right, they have a security interest. But here's the thing, Judge, it's not the debtor's money. It's not the GC's money. The Maryland Trust Fund statute applied to this transaction. And at least this $300,000 right here in that bank account of the $1 million that's there, that $300,000 this GC received on the project where I'm supplying labor and materials, and the GC holds those funds in trust for my benefit. It's not the debtor's money. They can't grant a security interest in that money. It's mine. Let me have it. I'm going home. You will win that case. Similarly, this is getting a little lawyerish, but let me at least mention, if you guys are familiar with bankruptcy preference cases, we do a lot of bankruptcy preference defense. That's the deal that you as a supplier, it's suppliers that most often have a problem with this, that you've been doing business with this debtor for decades. They file bankruptcy. First, you want me to try to collect what you're owed by this debtor, and that's basically going to come down to mechanics lien and bond rights. If you have them, I'm going to be able to collect some or all of your money. If it is unsecured contract debt, you're probably not going to collect, and there's probably not going to be any payout out of the bankruptcy. And that's the way that goes. And so you're unhappy that you lost $100,000 with that debtor. And then 2 years later, 2 years after the bankruptcy is filed, the client starts receiving notices about a bankruptcy preference. Please mail your check for $200,000 to the trustee. And you're calling me wanting to know, what is this about? And I will have to explain to you, well, yes, you lost $100,000. Yes, I was unable to collect it because you didn't have any mechanics lien or bond rights. But yes, you're going to have to pay $200,000 that you received in the 90 days prior to the bankruptcy that the debtor paid you. You're going to have to pay that to the bankruptcy trustee because it is a preference. Now, preference litigation irritates the heck out of me. And I don't blame you if it irritates you. It's really just a form of corruption, but that's a whole nother story. We don't need to get into that. But we do a lot of preference defense because it's very similar to what we do anyway, because the main defense, or one of the main defenses in a preference case, is for us to argue, well, no, judge, that wasn't a preference because we had mechanics lien rights. And if the debtor hadn't paid us that money, we would have filed our mechanics lien and we would have gotten paid despite the bankruptcy. And therefore, we're not preferred by receipt of that payment. And similarly, if the trust fund statute applied, it's even simpler than that. It's a simple case to prove the money that sub paid us, judge, this money that was paid here was always our money. It wasn't the debtor's money. So it cannot be a preference if it wasn't the debtor's money. And that really works. It's a great defense to a preference action. Okay, let's wrap up trust and then maybe we'll take a short break. So if this trust fund statute applies, any construction project in Maryland, if the mechanics lien statute applies or the Maryland Little Miller Act bond rights applies, then the trust fund statute is going to apply. But you have the opportunity in any contract that you are arguing, any contract you are negotiating, you can add a trust fund provision. And it's just like the provision that's in my will that I was telling you about for the benefit of my children, for their health, benefit, and welfare. You can have a trust fund provision. Let me find it for you. Here's your terms and conditions. Look at paragraph 8 here. Buyer agrees that all funds owed to buyer from anyone or received to the extent those funds result from the labor or materials supplied shall be held in trust for the benefit of seller and are trust funds. Buyer agrees they have no interest in trust funds, and that's all it takes. That is a trust fund agreement and will put you in the same position as if the trust fund statute applies. Now, I'll just mention, I don't think we're going to take the time to get into it unless we have time at the end. Your biggest single problem with a trust fund provision is commingling funds, whether it's kept in a separate account. The Maryland Trust Fund statute says that it doesn't matter. Funds can be commingled, so it doesn't matter that the funds from various construction projects are going into the debtor's general account. If you can show that they received $300,000 from this real estate owner a week ago from the project where you were supplying labor and materials, and the balance of that bank account never went below 300 grand in the 2 weeks afterwards, then that's adequate to trace those funds. And you can say, that's my $300,000. But in a private trust fund agreement, one thing you can end up arguing about is whether the funds were commingled and whether that breaks the trust. So anyway, if you're doing an escrow agreement, it's better to have a separate bank account, but that's not going to work for a supplier quote. Okay, I hope that isn't more than you need to know about trust funds. All right. Oh, now I can see the time. That's good. Hour 16. Okay, let's take 10 minutes or 5 minutes. I'll probably be back early and can take a few questions. You guys can type a question in. So we're gonna finish up talking about contract terms that you want to put in your proposals. Then we're going to shift gears and talk about reviewing contracts that you receive from somebody else. And so we'll 25 after the hour. We'll see you back here. I might be here a little sooner than that. All right. All right, we got any questions? I don't see any chats either. Let's see, stop share. See what we got here. Chat. I don't know, did I need to turn on the chat? I hope I didn't have to do something to turn the chat on. All right. Let's see, share screen. All right, back to live. Now, a trust fund provision in a contract doesn't hurt anybody on this, in these contract tiers or on this contract structure. In other words, one of the reasons I like trust fund agreements is you can sincerely say the owner wants it, the GC wants it, the sub wants it, and the supplier wants it. To put the same thing another way, Surely Contracting wants that term in every subcontract that they negotiate, and they also want it in between the sub and the supplier. It really benefits everybody. Who gets hurt by a trust fund statute? It's somebody outside of this contract tier, like the bank. And as we were saying before, people in the construction business would usually rather see the people in this contract tier get the money than the bank. Banks, of course, have a very different attitude about trust fund statute because it's one of the few places that you're going to be able to beat a secured creditor, beat a bank. Mechanics liens are another place. Of course, they don't like it, but let's see. It will beat, a trust fund provision will beat secured creditors, as we were just discussing. It will beat bankruptcy. It is a great preference defense. Your issues are going to be segregation and tracing. Tracing means you're going to have to show that that 100 grand right there in that bank account are the trust funds that came from the labor and materials you supplied. That's typically the lowest balance test is what most courts will take. In other words, if 100 grand hit the bank account from that construction project, and if the bank account has never gone below 100 grand since then that 100 grand did come from that project. Now, the unanswered question that I really don't know the answer, I mean, nobody does, is what if that's 2-3 different creditors can say the same thing? Well, each of us are owed 100 grand, and the bank account never went below 100 grand, so we all get it. What do we do? Share it? You probably do, or that's what a court would probably rule, but nobody knows the answer to that question. Segregation is a little bit different. It's about commingling funds. There is some case law that commingling funds breaks a trust, busts a trust. These are the older, cases where trust used to be a way that people held real estate and did business. So, but as I say, the Maryland Trust Fund statute, commingling is expressly permitted. That's one good cool thing about the Maryland Trust Fund statute. All right. So you can put a trust fund agreement in a contract, in a proposal, in a credit agreement. It's a really important provision in a joint check agreement. And again, that's a good example of where it's okay with the GC, it's okay with the supplier. It strengthens everybody's situation. The only person that gets hurt by that is the debtor who's now insolvent, or the debtor who was going to abscond with the money. Well, if you intended to never pay, we don't care that you're unhappy that there was a trust fund provision in the joint check agreement. And if you became insolvent, and then even the debtor is probably going to be happy that there was a trust fund provision so that their suppliers will get the money instead of the bank or whoever. All right. So reviewing contracts received from others. We are ready to shift gears now. We've been talking about the terms that you want in proposals and quotes that you send out, and in final contracts that you send out. A lot of those same concepts are going to apply. So we're going to end up reviewing a little bit and circling back. And you may have noticed I was talking about it earlier today, and we probably will keep doing that. Okay, I understand the business realities for the subcontractors out there. The business reality is that you're going to receive a subcontract from a GC, and there are going to be real limits to how much you can change it. GCs will often say you're not allowed to change anything in the contract. That might be okay if it's a fairly reasonable contract. That can be a real problem if it's a heavy-handed contract. And at the risk of irritating my GC friends, I have to say that that just plain isn't true. GCs always want to say you can't change anything on the contract. I would respectfully submit that it's a little more complicated than that. It's about, how important is this subcontractor to us? How important is this subcontractor to the owner? How low was this sub's bid? How sophisticated is this sub? How big is this sub? And how reasonable were the changes? And that's the main thing we're going to talk about. You're looking for the 5 greatest hits, is the way I like to put it. In other words, you are not in a position to be able to just rewrite the entire contract. If you were in that position, that would be great. You would have just drafted the contract to start with. And of course, that is always your first choice. Let me be clear, this should not be a surprise to anybody in the audience. You would always rather write the contract. When you're buying and selling real estate, a construction contract, anything, I don't care what it is. It's a naive mistake that I've seen not very many people make, but some people make, thinking, well, let them incur the legal fees to draft that contract. I don't want to do that. I don't want to pay Fullerton to draft the contract. Wrong. You always want to write the contract when you have the opportunity. And you're going to pay me less to just get a contract form that I'm familiar with and just let me give it to you and change the names on the form and send it out. That's going to take less time than it's going to take to read a 35-page contract from whatever GC it is or owner it is. And that's going to take a lot longer. And you end up, there's limits to how many changes you can make. You can't just rewrite the whole form. You're looking for the 5 greatest hits. You're looking for things that are most likely to cause real life problems. You're looking for things that you can get the customer to change, that they're more likely to agree to. And you're looking for things you can change with a small number of words. You're going to have a hard time just crossing out whole paragraphs and adding an addendum of 3 pages. You're not usually going to be able to do that. So number one, you're looking for things that are really going to pull money out of your pocket or really be a problem. And the example I like to use there is an indemnity clause. I seem to get a lot of questions about indemnity clauses. That's the one that says, subcontractor agrees to indemnify and hold GC harmless from any and all accidents on the project, and whether, even if the GC is partly in fault and all this stuff. I agree that language is very spooky, and I'm not surprised it scares you, but my answer is usually, well, we do need to look at the indemnity agreement. Indemnity agreements can be so far out of bounds that they're putting an unfair amount of risk on somebody. But as a matter of fact, both Maryland and Virginia have statutes that say an indemnification provision is unenforceable if it forces somebody to indemnify a party for their own negligence. In other words, a lot of indemnity agreements say that sub will indemnify and hold GC harmless even if GC caused the problem. That is an unenforceable agreement, but it's an example of an indemnification that you do need to notice you cannot agree to if you happen to be in DC where there's no such statute, but that's unusual. Most indemnification provisions are what I call insurance provisions. The most important thing to do is send the contract to your insurance agent, and I mean it, do it. Send your contract to your insurance agent and say, please confirm to me that the insurance policy that you sold me and that I'm paying you on a monthly basis for will insure against the risk described in this indemnification provision on this project. And insurance agents will answer that question. That's their job. And most of them are very good about doing that. And they will help you learn, and I will do the same thing, help you learn how to just recognize an out of bounds indemnification provision from one that you can just ignore. In other words, you have to know what things to worry about and what not to worry about. You want to pick out things you can get the customer to change. Some things are just patently reasonable. Some things are just, and you're more likely to get somebody to agree to something that is obviously reasonable. You're more likely to get a customer to agree to change things that are obviously unfair. And you're also looking at things you can change with a small number of words. It also surprises a lot of people to find out you give me a 35-page contract to review and revise. It would be a lot faster if I could just add a 15-page addendum. That would be faster and it would get the job done. It would give you a lot more protective provisions, but that's not a choice. it will actually take me longer to read a 35-page fine print contract and then figure out where I can just change 3 or 4 words or add one sentence and get a big change in the leverage and the risk in a contract just with changing a few words. That's the art of reviewing contracts received from others. All right, the first thing you're going to do is incorporate your proposal or quote, which we mentioned earlier. Every proposal you do in the future, every contract you ever submit a bid on, you are going to check the plans very carefully, make sure you're quoting off the most recent plans, make sure you're quoting off the same plans that are described in the subcontract, the bid package that you receive. You're going to make sure your exclusions are added, all of the things you're used to doing, but you're also going to have that 8.5 by 8.5 by 11 sheet of paper. That one sheet of paper, here it is going to be attached. Here's the front part of your quote. Here's the 1 page of legal terms. And that is going to be attached to the subcontract that you received, attached as an exhibit. It works just as well legally if you can add this provision shown on the screen, just one sentence. You say, seller's proposal dated such and such is incorporated herein by reference. That's all it takes. Your 2-page quote, your 2-page bid is now a part of the contract. Now, to digress a little bit here, I want to make sure you guys understand that if you do not do that, if that is not added to the contract, your bid vaporizes the minute you sign that subcontract. I wish I had $5 for every time, every case I've had that, the client's saying, well, this happened and that happened. And we had all these costs and we had all these damages. And I'm saying, but look, you signed a subcontract that said this and that, and now you're stuck with it, which is generally the rule. I mean, that's the courts enforce the contracts the way they are written and the way you agreed to it, particularly in a commercial setting like this. The courts just figure you're big boys and girls, you're business people, you're sophisticated. If you need to read your contract, and that's even more true in Virginia than Maryland, but it's true both places. And one of the things, the subcontract you sign, one of the things it says is, this agreement takes precedence over any prior negotiations, any correspondence are now irrelevant. This is the total agreement between the parties. That's what you call a merger clause. All prior writings, all prior negotiations are merged into this subcontract that you're signing. Now, almost every subcontract you sign, that's what it says. And the courts will enforce that. You might be surprised to find out that that is the legal term, whether the contract says so or not. Even if your contract does not have a merger clause, that is the rule of law. If there is a final agreement, and you can argue about whether this is a final agreement, you can have that kind of argument. But if this was a final agreement, then all prior negotiations vaporize. And if you think about it, it's going to make you mad when the time comes, but that's the way we want the rule to be. We don't want, it hinders commerce, it generates disputes. If people are allowed to go back, however far back in the past they want to, and say, but wait a minute, I sent you a letter on, 3 years ago saying this, it just creates uncertainty and hinders commerce. So that is the rule of law. If there's a final agreement, everything else dissipates. And most of the contracts you sign say that explicitly. They have a merger clause. And so your bid, your proposal vaporizes the minute you sign this subcontract, unless this one sentence makes it part of the new final agreement you're agreeing to includes your two-page proposal. And that's where you want to get. Now, when I'm representing GCs, I tell them to be very careful about that. And that's the negotiating range. That's where the tension is. But as a creditor, a GC wants to add this sentence to every general contract they have with every owner in the planet. They just don't want their subs putting it in the subcontract. All right. So one thing this means, on your proposal forms, you need to include a draw schedule. I should have pointed this out before. Actually, I ought to move this slide earlier, give you a new share. I should have to remember to put this slide earlier. I'm going to write that down. Let's see. Slide earlier. Okay. You put the price in here, the total price, but you see payment terms right here. How much down, what kind of deposit do I get? And you want to at least say to be paid monthly for work in place. If you expect to be paid 90% of the value of work in place on a monthly basis, 10% held as retention, you need to say so. Otherwise, the general rule of all contracts is payment is due when the work is complete. And if you're working on a project that's going to take you 2 days, that's not a problem. You'll just get paid when you're complete. But if you're going to be working on a project that's going to go on for 9 months, you're not going to want to finance it for 9 months to get paid. And so just in case your bid becomes the contract in connection with the scenarios we were talking about earlier, that the debtor, the owner actually signs your proposal form, or they never submit a more detailed contract and they just say, get your rear end out there and start work, which I think you're always happy to do, or always, it's overstating it, but most of the time that will work out better than if you force them to give you a detailed contract. In both those cases, this is the contract. And if all you did is identify the $386,000 you're going to get paid, then that's how much you're entitled to be paid as soon as you are complete. You will not have progress payments. So that's why, just in case this ends up being your contract, make sure you put payment terms in here. That's what this slide means. All right. At least you want to say paid monthly for all work in place. You got to know your government regulations. That's really a residential thing. And most of my clients are commercial contractors, and I think most of you guys are, but consumer home improvement particularly is highly regulated, and there's a lot of rules about what minimum requirements in a contract. So if it is a home improvement contract or even some new construction, but it's mostly home improvement, you have to make sure your contract form that you use complies with the rules your state has. Okay, the next most important thing you're going to look out for is this. Take a minute to read that provision. This is a default provision. If seller breaches any provision of this contract, then buyer may declare this contract in default and terminate it on written notice to seller. Here's my question for you. That's what your contract says. you just received written notice of termination. What opportunity do you have? What happens now? Answer is, and again, I'm sorry, it's not a live seminar, but the answer is, if you're lucky, you can gather your tools and take them with you when you leave. This does not say you have an opportunity to fix it, that you need to get out on the project real quick and fix the problem, and you can avoid termination that way. There is no notice or opportunity to cure. That is patently unreasonable. A judge will enforce this the way it's written, because you are a sophisticated business person, and if you didn't read it and you didn't think about it, that's your problem. But if you say to even a real tough general contractor, if you say, well, wait a minute, are you telling me that if you're 90 days late paying me, I can't do anything about it and I have to keep working? But if I am a day late showing up on a project, or I forget to flick a switch somewhere, you can immediately terminate me and just send me a notice, and there's nothing I can do to fix it. You're not going to give me any notice. The GC is going to say, or the owner is going to say, well, sure, I'm going to give you notice. I'm always going to give you written notice. You say, oh, thank goodness for that. That's all I want to do is say that in the contract, that before you can terminate me, you have to give me notice of the defect and give me an opportunity to fix it. That is patently reasonable. You can get people to agree. It doesn't take that many words to change. And this is exactly what you do, is you get a pen, you do a little arrow here, whoops. You do a little arrow here, you go take, and it's better to do it with a ruler, it's usually neater. Draw a straight line out here, put a straight line down the margin, and right in that line you write, and seller does not begin to diligently cure such breach within 10 days after receiving written notice specifying the breach. Now the buyer can declare this contract in default and terminate this contract. Again, we had these provisions in the proposal the way you sent it. If that is attached, your proposal is attached as an exhibit, you got it to be part of a contract, that's good. Some terms are going to be in conflict. What the big contract says and what your attached quote says will be in conflict, but that's great. I'm always happy with that. You'd rather have a contract with terms in conflict, some of which help you, than have everything going in the debtor's favor. It just makes it harder for a judge to help you. If you got that proposal attached and it's an unfair situation and you deserve to be paid, that's enough. A judge is going to help you. And plus, I would want to make this change in the body of the subcontract, whether your proposal was added or not. But I just wanted to point out your exhibit added is another way you might fix this problem. But notice both of those, what it says in your proposal and what it says here. It is written notice. The written notice must specify the breach. Both those are important. And notice that it says it gives you the burden to begin to diligently cure such breach within 10 days. I don't care if it's 72 hours, that's fine. But I want it to say, gives you the obligation to begin and diligently continue to cure. Not that you're going to fix it within even 10 days or 30 days. Some problems take more than 30 days to fix. What matters is that you are diligently curing it, doing everything you can to cure it. All right. Waiver of mechanics lien and bond claims. I used to always say, find them and cross them out. critically important. Otherwise, you're just deciding to be a general unsecured creditor. You're deciding to be the credit card guy instead of being the mortgage guy. And that will dramatically increase your costs of doing business, increase your risk, and lower your profit. And that is still the case in a lot of states, including the nation's capital, which isn't a state, but in District of Columbia, they do not have any kind of savings statute. But as a matter of fact, Virginia and Maryland had one longer. Virginia's only been around a couple years, but they both have protections now that a waiver of mechanics lien or bond rights that is in the body of the contract and it's signed before the labor and materials are supplied is not effective to waive lien or bond rights. So that's a very helpful thing. However, let me point out now, this is jumping ahead, March the 9th, a waiver signed after the contract is signed is effective everywhere. A waiver signed after the labor and materials is supplied is effective everywhere. And you guys sign those on a daily basis. They're called progress payment waivers. And we'll talk about that at some length on March the 9th. But you need to have somebody in your company that's very competent at reading progress payment waivers and make sure that you're not waiving your lien or bond rights for retention, for change order work the paperwork hadn't been processed yet, and these sort of things, because those waivers, you will be stuck with those waivers if you don't find them and cross them out. The Virginia and Maryland contractual protections are not going to help you. All right. Now, the big argument nowadays, or one of the biggest negotiating ranges or negotiating issues, is what I call contract schedule unilateral amendments. And I'm reminded, I remember the first time I ever saw a pay when paid clause. I thought it was the most outrageous thing I had ever seen in my life. But now, it's another day in the office. They're going to be in every contract you sign. Get used to it, which we'll get to a little more later. But conduit clauses, same thing. They're going to be in there. It's not something anybody's going to agree to change. Don't worry about it. Pay when paid clauses are not something somebody's going to agree to change. Learn to live with it. This is the new battleground. Contract schedule unilateral amendments, and it's worded something like this. Buyer in its sole discretion from time to time can change the time periods or durations or the sequence of work set forth therein. What does that say? Let me translate that for you. What that says is, I'll let you know what the schedule is when I'm good and ready to let you know what the schedule is. And if you don't keep up with it, you're in breach of contract. You cannot agree to that. Here's another one. This one's more detailed, which probably makes it even more enforceable. Even if the schedules differ materially from the schedules set forth in the contract documents, time is of the essence. Now, a lot of people, time is of the essence scares a lot of people. And the main reason I have that on this clause is just because it reminds me to tell you, you're okay with time is of the essence. You don't need to worry about crossing that out because time is of the essence. It always is. What that means is time matters. Time is important to us. Time is a material part of what we're negotiating here. And we care about the schedule. And if you don't keep with the schedule, you're in breach of contract. You're okay with that. If you're not okay with that, you better go in another line of business. What you have a problem with is the buyer's rights to amend the schedules, even if they differ from the schedules they attach to the contract. Now, will judges always enforce this? there's a lot of argument about that right now, but you can't take a chance. Judges are going to enforce that sometimes. In any event, it's an invitation to send me a lot of money to argue about it for a very long time. So anyway, you gotta change that. And the way that you change it is one of two ways. The word reasonably counts for a lot. What does reasonable mean? Yeah, it's a vague standard. We can all agree on that, but it means something. And I like to say, I remember Vic Rinaldi, who hired me right out of law school and taught me how to practice construction law. I remember he used to say, you just got to give the judge a hook to hang their hat on. That's all you need. That give the judge something that they can say, well, wait a minute, but that change to the schedule was not reasonable. It was very difficult to conform to the new schedule. It was very costly. You gave very limited notice. It was not reasonable. And if it's an unfair situation, it is enough. You're putting a judge in a position that they can rule in your favor. If the judge is going to enforce the contract the way it's written, and you got to make sure you're giving them something to work with. Because if everything's going in favor of the other guy, you're going to have a problem. The other way to do it, it's better to do both, but the other way to do it is say amendments are only by mutual agreement. This last sentence, what I've added here is what's called a force majeure clause, which I think there's another slide about this later. But it says seller is not responsible for delays caused by conditions beyond its control. Some people think that's always the case. You know, I'm not responsible for things I can't control. If that's the way you want it to be, you have to say so in a contract. You are responsible for delays beyond your control unless you say otherwise. To put the same thing another way, if you sign a contract that says this house will be complete by March 1, it doesn't matter how many nuclear bombs hit. It doesn't matter how many floods or hurricanes you have. It doesn't matter what the owner does. If you don't finish by March 1, you are in breach of contract. If you mean to say you're not responsible for delays beyond your control, you need to say so in the contract. That is normally called a delay clause, or a force majeure clause is a French term that's normally used. Okay, here's another version of the same thing. Agrees to start work within 48 hours of written notice and complete work in accordance with the schedule as established and amended from time to time. Again, you know now how you deal with that. Reasonably, by mutual agreement, you're not responsible for delays. They may not let you have this last sentence. That's really changing things more, but it's very hard for somebody to say, no, and I've had lawyers tell me this before. It's kind of funny. No, I'm not going to agree to be reasonable. No. And they mean it. At least they're being honest about it. Most people will say, well, of course I'm going to be reasonable. Fine. Well, let's just add that one word. Let's just make that clear. By mutual agreement is stronger. That's better for you. That may be a little harder to get, but you'd rather have that. You'd much rather have force majeure clause, which AIA contract has a force majeure clause. I mean, most standard form contracts, you are not responsible for delays beyond your control. So it's very reasonable. But whether you're going to get somebody to agree to it's a different question. All right, so contract schedules. You would rather have a definite start date and a definite finish date. Most construction contracts are based on a notice to proceed, and you're probably going to have to agree to that. In other words, they're not going to say when the contract's going to start. And, you'd really rather have a definite start date. But this comes from the government contract scenario. The government insists on this, that they don't know when the Congress is going pass the budget. They don't know when war is going to start or whatever it is. So you're going to start on a notice to proceed. And since that's normal for government contracts, it's kind of become the norm even for private contracts. So we don't like it, but you might have to agree to that. You can get a contract schedule, that you get blank number. You have 140 days of unimpeded access to the site after the notice to proceed. You'll have 140 days to finish. And you can build that up a little more, a little better, unimpeded access that you'll, have clean access or whatever. We'll have some more slides later. You cannot agree to an unknown schedule. You cannot agree to modifications of the schedule without an agreement. Make sure you are at least limiting the modifications to reasonable modifications. Force majeure, you would rather have. Yep, we do have a slide. This is what my Appendix 5 says, the labor and materials contract or quote or bid says both these things, goes even a little bit further. You have, it all depends on the availability of material, weather conditions, prompt cooperation of the buyer, free access to all work areas. And here's your force majeure, not responsible for causes, conditions beyond your control. You would rather have that in your quote and put it right in your contract if you can. Interest and attorney's fees, an important topic. And again, this is a big leverage term. We need to wax philosophic for a minute and think about who has the burden of changing the status quo. Putting the same thing another way, who cares the most about attorney's fee provision? I would submit to you that it is the creditor, the person trying to collect money, who cares the most about it. An owner doesn't need an attorney's fee provision usually. They have your labor and materials, they have your money. If they want you to do something, they just say, please do this. And until you do, I'm not giving you another dime until you do this. That's going to be enough to motivate you to get out there and fix whatever the problem was. It's probably going to motivate you to get out there and do what the owner wants, whether you think it was really in your contract or not. The owner has all the leverage they need, just holding the money. But the GC, as the creditor, has the burden of changing the status quo. Again, the owner's got all the labor and materials, they got all the money. How are you going to motivate the owner to pay? And I have clients all the time ask me, well, what do we do about that? What can we do? And I always say, there's only one thing I know how to do, and that's file suit. You have to put, and I don't know what else you can call, you can write letters, but that isn't going to help. A mechanic's lien would be a big plus, or just file and suit. You have to put the debtor in a position that his failure to pay is starting to cost him money, starting to pull money out of his pocket. And as we discussed earlier this morning, the attorney's fee provision is a big part of that. So who's the seller, who's the creditor, who's the buyer, who's the debtor? All right. Now, you have to understand the difference between a unilateral attorney's fee provision and a bilateral one. We just finished talking about unilateral amendments to the contract. That means just one of the two parties can change the schedule, and only one. The owner can change the schedule on the GC cannot change the schedule. That's unilateral. Similarly, the attorney's fee provision we were looking at earlier said if purchaser fails to pay, if purchaser breaches the contract, they're going to be liable for 33% legal fees. That was a unilateral provision. The general contract that you receive as a GC from the owner and the subcontract that a sub receives from a GC is probably or may have a unilateral attorney's fee provision. It says if GC breaches this contract, GC shall be responsible for all attorney's fees incurred by owner. That's a unilateral attorney's fee provision. Now, one thing you have to understand is that does not work both ways. I get that question sometimes. If this is what your contract says, the owner can make you pay legal fees if you breach, but you cannot make the owner pay legal fees if they breach. You're a grown-up, sophisticated business person. You agreed to it. You're stuck with it. But that's a hard thing for somebody to justify. And you can get on the phone with the person you're negotiating this contract with. And you can say, well, let me get this right, owner. If you can just fail to pay me for 6 or 9 months for whatever reason, maybe you have financial difficulties, maybe there's plan defects, you can just hold me up for a year from paying me, and you're not going to be responsible for any of the costs I incur. But if I just miss one little thing in the plans and specs, and I don't pay for it immediately, I'm going to be liable for all your legal fees. The owner's going to say, oh no, yeah, I mean, it's patently unreasonable. You can get people to agree to change this. It's easy to change. You can change it in just a couple of words, and it really makes a big difference in the leverage that you have. You're just changing, you're striking out 4 words, you're adding 3 words. You have changed the unilateral attorney's fee provision to a bilateral provision. Now, either side, whoever breaches the contract, the innocent party is going to be able to collect legal fees from the breaching party. That's reasonable. You care as a creditor, that's a lot more important to you than it is to the owner or whoever the debtor is, because the debtor can just hold the money. All right. Or you can just add a bilateral attorney's fee provision. This is a good policy also. And this is a good term right here. And this is in the book on page 2-30. I forgot to remind you again, I'm working through, remember, we looked at the table of contents, the reviewing contracts received by others. All of this stuff we're talking about here is in the book. You can look at it anytime you want. And this sentence is in there. This is just a good single sentence, bilateral attorney's fee provision. You just write it in the margin at the top of one page of the contract or in the margin up the side. You can fit it a lot of different places, and you've dramatically changed the leverage in your contract. All right, authorization to verify funding. As I mentioned earlier, we were talking about terms you want to put in your proposal that says, I have no obligation to begin work until you show me that you have the money to pay for the work. A lot of people are surprised to find out that that is what the AIA contract forms say. They always have said that. As a matter of fact, it's gotten watered down a little bit in the last 20 or 30 years. It's not quite as strong for the creditor as it used to be. But it still says that at the beginning of a contract, the contractor shall have no obligation to commence the work until the owner provides such evidence. And so you, if you are a GC, and see, this is in the subcontract also. So everybody on the contract tiers, the sub and the GC, you can consider making this requirement. And I have GC clients that do require this on every project. If they're multi-million-dollar contracts, show me that you have a loan commitment, is the most common way, or give me financial statements showing your multi-million-dollar net worth. All right. This is how the AIA document has been changed. It used to say, going back to the earlier slide, that it used to say you could ask at any time for evidence of funding, and you have the right, you have no obligation to commence or continue work until you have that evidence. Owners were arguing and complaining for decades that gave contractors too much power. And there were some contractors that were just constantly asking for evidence of funding. I'm not sure it was such a problem, but again, I always represent the creditors. So where we ended up, this is what the contract says now. After following commencement of work, after work has started, you're allowed to ask for reasonable evidence of financial arrangements only if the owner fails to make payments, misses a payment. That's enough. Now you can say, okay, show me you got the money, or I'm not continuing. The contractor identifies in writing a reasonable concern. What does that mean? I don't know. It's vague. We talked about that word reasonable. It does mean something. Although it's a little hard to say exactly what it means. But I really want to emphasize number 3, a change in the work materially changes the contract sum. This is when it's going to be critically important. And what I'm thinking of is, there are defects in the plans and specifications. The architects and engineers are reworking the plans. That is a sign that the project is in trouble. Do not make the mistake of thinking, oh my goodness, I'm going to get rich on this project. Change orders galore. I'm going to be able to up my profit margin. That might be true. But amongst other things, when that happens, you need to ask yourself whether anybody's got the money to pay for this. If a project is delayed for 6 or 9 months for whatever reason, the budget just went up 10%. Did the bank agree to lend that extra $1 million? Does the owner have that extra $1 million? If the owner starts getting in trouble, if the project's in trouble, is the owner going to say, ooh, I better just find my checkbook and get my savings account and put another $1 million in this? No, the owner's going to rationalize in their mind somehow that this is the GC's fault or one of the sub's fault or not the owner's fault. And even if they agree it's their fault, they're not going to just write a check. You, creditor, must be in a position to say, wait a minute, I'm not going to lend you another $500,000, owner, unless and until you show me you got the money to pay for the material changes in this contract. The budget has increased 10%. Show me the extra $1 million. All right. Conduit or pass-through provisions. Hold on. Let me see. I got to remember to put a clock in my, I have no idea what time it is. All right, conduit or pass-through provisions. That's the term that says the provisions of the general contract are incorporated herein by reference. Or it might say the seller shall be bound to the GC to the same extent that the GC is bound to the owner. Those are really just 2 different ways of saying the same thing. Most of the contracts you sign are going to say both of those things. That's what the conduit is referred to as, a conduit or a pass-through provision. The subcontract is just a conduit. All of the terms of the general contract are passed through the subcontract to the subcontractor. All right. Now, the first thing, you're not going to get anybody to delete a conduit clause, or you're rarely going to be able to do that. If you're in a position to do that, you're in a position to say, no, we're not using your contract form. You're using my contract form. Suppliers can do this sometimes. They used to be able to do it a lot more often, where they would just say, oh no, we signed our credit agreement and our terms of sale, or you don't get materials. Nowadays, one of the things that's really changed in the last 40 years that or 35 years I've been practicing law, suppliers used to be able to do that. And I've always represented a lot of suppliers. They used to be able to say, you know, you can sign my credit agreement if you want materials. Nowadays, suppliers are receiving purchase orders that look a lot like subcontract agreements, and has a lot of terms in it that you would find in a subcontract, including the conduit clause. Now, this is a frightening thing for suppliers. You know, to be honest with you, it's getting to where they're probably going to have to agree to it in some instances. Depends on how big the order is, depends on how big the buyer is, you know, depends on a lot of things. You might have to agree to it sometimes, but you would always prefer, you're not going to, nobody's going to let you strike out a conduit clause. If you could do that, you could just say, no, we're not using your contract form, we're going to use my form, you know, and just change the whole contract. Or you're going to be able to attach a 2-page addendum. Actually, before I forget, maybe I do have a slide on this. Any of you guys that email me, I have I believe it's 2-page Word document, addendum to subcontract, or you could also use it as an addendum to a general contract you've received from an owner. And I have clients who swear that they successfully just staple that on subcontracts that they receive. And I find that a little hard to believe, but I hope it's true. It's great. And it's similar to my 1-page, 8.5 by 11 sheet of paper with all the terms. It's 2 pages of everything, you know, saying, eliminating the conduit clause, eliminating the pay if paid clause, eliminating the unilateral schedule amendments, you know, all this, all of the things you want to change in a contract that you receive from an owner, all of the things we're talking about here, it's on one 2-page document, and it's not on the website. I think we do have a slide at the end of this PowerPoint, but I'll email it to you if you email me and ask me for it. And you can attach it to any contract that you're doing. Okay, let's get back on task here. Since you're not going to be able to cross out conduit or pass-through provisions, here's what you're going to do instead. Number one, if you're a sub, you're going to get a copy of the general contract. No excuses, no exceptions. And I tell my GC clients very sincerely, I tell them all the time that they want to provide it. In fact, the bigger, more successful GCs nowadays, they got a website for each project, and everybody who's bidding on the project, or at least everybody who has a subcontract that they've signed later, they can go right on the website. They can see the plans, they can see the specs, they can see the current schedule, they can see the general contract. And I think that's the best policy for a GC, because, and you know, if I'm doing seminars for GCs, that's, you know, exactly what we're telling them. We are expecting these subs to comply with every term in the general contract, and we want to be able to slam them if they don't. And you can't do that unless the sub is able to see the general contract and what it says. So flip side, if you're a sub or you're a supplier and you're having this conduit clause forced upon you, you must get a copy of the general contract. Go to the GC's office if you need to. This is a little bit dated, but the way it used to be 20 years ago, GCs would say, oh, well, we're not going to send you a copy. We didn't even have emails in those days, or 30 years ago, we didn't. We're not going to give you a copy of the contract, but you can come to our office to look at it. If somebody says that, get on your horse, get over there. When you arrive, they will probably give you a copy of it. The nice young person who's working out in the desk, they're going to want to just make a copy to get you out of their office, and so they can get back to work. And you usually can get a copy. But even if they're really going to make you read it and take notes, one of the things I want you to understand is that you don't have to read that 35-page contract and take notes on the whole thing. What you care about, what you need to know is what are the claims provisions? How do you make a claim for a change order? What's the time limit to make a claim for a change order? What's the time limit to make a claim for a time extension? How do you request a time extension? And what's the dispute resolution procedure? Arbitration, litigation? Do you have to meet with the architect first? Those are the only two things you care about. And that's just like 1 or 2 pages of this 45-page contract. That's the part you need to read and take notes on if you're at the GC's office. In real life, in modern life, you're probably ask for a copy of the general contract in writing. Ask them 5 or 6 times in writing. GC, I need a copy of the general contract. The subcontract you sent me requires me to comply with each and every term of the general contract, and I can't do that if you're not going to give me a copy of it. If you can show a judge you sent 3 or 4 emails like that, and the GC never gave you the contract, and now the GC is saying, well, wait a minute, this sub isn't entitled to a change order because he didn't give notice of his claim within the time and in the manner required by the general contract. If those are the facts and you asked for that general contract several times and the GC didn't give it to you, the judge will hang the GC on that. They will not prevail in that case. So you want to make sure you're requesting it in writing. And then flip side, as I said a minute ago, my very sincere advice to all my GC clients is to give it to them. In fact, I think it's better just to have a website. So you're looking for the claims procedure and the dispute resolution procedure, which is exactly what we're going to talk about for the next half hour until closing. All right, change orders. Most contracts say there will be no payment for changes unless ordered in a signed writing. That means what it says, and it is enforceable. A lot of clients are surprised to find out that the Virginia Board of Contractors regulations state that it is a violation of the licensing regulations to perform change order work without having a signed change order prior to the work to be performed. And I represent a number of very large GCs, and that always just shocks them. They're like, what do you mean? Changes are never signed before they're performed. And I know that's true, but I also want you to know it's actually a violation of the Virginia Board of Contractor regulations. If nothing else, that's something you could point out to your customer, that they're asking you to violate the regs. But in real life, there's really another solution. Change orders are never signed before work. I understand that. That's real life. All that does is it moves you over to the claims provisions. The part that says for extra time or money, You have to give written notice of any claim within 48 hours. You have to send notice one place, two place. You must send a copy to the architect. It must be within 24 hours. It must be within 70, whatever. That's the claims procedure. You need to know what that claims procedure is. As we'll talk about in a minute, a sub needs to know what the claims procedure is in its subcontract. You need to read it, but you also need to know what's the claims procedure in the general contract, because any note, any claim that you make, any change order you submit is another, it's not technically correct. It's a claim, not a change order, but you're now in the claims procedures. You have to comply with your subcontract and you must comply with the general contract. Okay, it means what it says. It is enforceable. The best way you can give notice of a claim is with a PCO, proposed change order. Go ahead and fill it out and send it in. That is adequate written notice of your claim. Just go ahead and submit a change order. But what's even more important to me that you understand, you may not have time to do a change order. You may face an emergency. You're always going to face an owner pounding on the table saying you're going to be in breach of contract if you're not out there immediately to fix this. I understand that. What matters is the notice. You must provide written notice before you begin that work. And you need to get in the habit of saying, sending emails or a text. I personally don't like texts at all. And I'm sorry, let me digress here for a second. Texts are a problem because the only way to keep copies of those written records, they are written records. It is the same as sending a letter, but the only way to keep copies is to print them out and scan them in. Whereas an email, I still have access to emails I wrote years ago. They're just much simpler, and you can sift through them and you can print just these 4 emails that are relevant to this dispute we're having. It's just a much better way to preserve the evidence. I just hate it when I ask a client, well, did you give them written notice of the claim? Well, there were texts. I'm like, oh my God, I'm going to get 75 pages of text, and I'm going to have to go through them all and find, because the client's not going to be able to do that, frankly, or usually not going to be able to do that. You got to hire a lawyer to flip through 72 pages of text to find the place that you gave them adequate notice of that claim. Whereas an email, you got electronic copies. I can search it for certain words. Emails are better than text. Thank you. I apologize for that digression, but let me get that off my chest. So change order is a writing. So I do want to point out there is a difference between the notice of the event and what I call the quantification of the claim for time or money. And again, I want to emphasize you must give notice of a claim in the event there's a change in the schedule or a change in the scope and the money, either one. Sometimes contracts compress these two things, the notice and the quantification, by saying something like, if sub creditor thinks that any event has occurred that will delay the schedule or will entitle them to extra money, they will submit a proposed change order immediately and before beginning any work, with a complete time impact analysis, with a complete budget, copies of all proposed materials to be used. That's the quantification. That's the final change order package you're submitting. It's not going to be possible to provide all that information. If the owner's saying, make sure you have your rear end out here this afternoon to do this. You're not going to be able, a lot of changes, you have no idea how long it's going to take till you do it. You have no idea what it's going to cost until you do it, or you have no idea for a little while. You don't need to sweat. That is what I'm saying. What you do not let that stop you from providing notice. It's the notice you will get hung on. A judge is not going to hang you for failure to provide the quantification, especially if it was just unreasonable. If you can make a decent case that it was impossible to give a complete time impact analysis before I began this work. But I did give them notice. Here's the email that I told them. Okay, owner, we'll be pleased as punch to get out there. We will get out there immediately and will diligently work on this. But, oh, I'm sure you understand this is going to impact the schedule significantly, and it's going to cost some extra money. We'll follow up with details as soon as we possibly can. That is your notice of the event. That is the part the judge will hang you on, and I understand why. I've represented enough owners and enough GCs to understand why. The owner is absolutely entitled to that notice, and it's the way it needs to be. Because if the GC says to the owner, or the sub says to the GC, and it's passed through to the owner, that no, we think that is a change that is going to delay us 2 weeks in any event, and it's going to cost extra money, and we're going to ask you to pay it. If the owner gets that notice, the owner might say, never mind, don't do that. Or here, I'll do it this way instead. Or let's just agree to make this change instead. Will that result in a delay? The owner is absolutely entitled to the notice. To put the same thing another way, it's a very common fact scenario that a contractor will just pocket all these change orders. I mean, I've had this case 100 times, especially residential construction, home improvement, that the contractor gets to the end of the project and submits all these change orders. You're not going to be able to collect for them. Not only is that going to be impossible, I have complete understanding why. It's patently not fair. It probably violates your contract. It certainly violates the Virginia Board of Contractors regulations. And the owner was absolutely entitled to that notice of the event. So the claims procedure in the contract, you must follow the exact procedure when you give notice, to whom you give it, form of the claim, when you got to give the quantification. We've really talked about that. The sub has to follow the lowest common denominator is the term I have to use. The sub and the supplier has to be aware of the claims procedure in the subcontract and in the general contract. Same thing, when to give notice, to whom, the form of the claim. You must put the GC in a position to forward the claim to the owner in accordance with the general contract. And again, I've represented GCs long enough to know that that's the way it has to be, and it makes perfect sense to me. I don't know, probably at least once a year, or once every other year, I'm in a telephone conversation with some sub's lawyer, with a sub or a sub's lawyer, and they're saying, but God damn it, you told us to do this work, you watched us do it, and you're not going to pay us for it? And my response is, well, wait a minute, let me get this right. You put me in a position that made it absolutely impossible for me to force the owner to pay extra money. You made it impossible for me to submit a claim to the owner within the time and in the manner required by the general contract. And now you want me to come out of pocket to pay you for that change, that is not going to happen. That's where you end up. And that's what you have to understand as a sub or a supplier. You must put the GC in a position to forward the claim to the owner in accordance with the general contract because of the conduit or the pay if paid. If you think about it, either one of those clauses works the same way to nullify the sub's right to a claim. All right. Dispute resolution is a little different, not quite as important, but it is important. We could talk about this a very long time, and it can get very lawyerish. And I'm not sure we want to do that, but we want to take a few minutes. That's talking about the difference between litigation, arbitration, mediation. There is some dispute resolution procedure in all contracts. It might say, in the event of dispute, the parties shall meet in good faith to try to negotiate a change. And I'm here to tell you that will be enforced by a judge. I have had more than one case where somebody filed suit against my client. I made this argument once successfully. Somebody filed suit against my client, and that took them a month to file suit. Then I had 21 days to answer. Then, it's another month before we have a motions day and we're arguing this motion. And I brought a motion to dismiss, saying, well, this lawsuit needs to be dismissed, Your Honor. The contract says in the event of dispute, the parties will meet, try to negotiate a resolution before resorting to any other dispute resolution procedure. They didn't do that. They just sued us. A judge, number one, they're going to enforce the contract the way it's written. And number two, they're always love the idea of just getting a file off their desk where they don't have to spend any time on it. A judge will enforce that. And they may dismiss the case. In my case, they said, okay, case is stayed until you go do this negotiation. So I was just able to delay the case another couple of months because they failed to have the good faith meeting. Sometimes it says you got to submit your claim to the contracting officer. Sometimes it says you got to submit it to the architect. Sometimes with public contracts, public procurement, you have to submit the claim to the Board of Supervisors of Fairfax County. And you have to wait for them to make a decision. And only after that can you file suit against the county. And I have seen that kill claims because then you must file suit within 30 days after the decision of the Board of Supervisors. If you miss that deadline, you're SOL. So anyway, these are the dispute resolution procedures. And so there's a discussion about them generally, but I also want to make sure you understand as a supplier or a sub with a conduit provision, you care about what the general contract says about that. Because if there's any event caused by the owner, and most changes are, a change in the plans and specs is an owner change. Most changes are owner changes, or in any event, as a sub or a supplier, you have to operate on the assumption that all changes, all delays are owner caused. You must forward your claim to the GC within the time and in a manner to allow the GC to submit that claim to the owner in accordance with the general contract. You must always do that because whether it really was an owner change or not, the GC is going to claim it was an owner's change and they're going to say, pay if paid. If I don't get paid, you don't get paid. So as a sub or a supplier, you care about the claims provision in the general contract, you care about the dispute resolution provision. Otherwise, I was real glad to see the change. I'm not sure how many slides we have on this. I might repeat this again in a minute. But I was really glad to see the changes in the most recent changes in the AIA contract. It used to just always be arbitration. I am not a big fan of arbitration. I don't like it. I do not believe it is faster. I do not believe it is cheaper. I think it really increases the chances a case will be tried. It delays cases being resolved because people with weak, courts will tend to enforce the contract the way it's written, and courts will tend to follow the law the way other courts have set it and the way the legislature sets it. Arbitrators are more likely to just say, well, that's just not fair. I know the contract says that, but arbitrators are allowed to be arbitrary. They're not required to follow the law. There's very little, there's no right to appeal what an arbitrator does. And that makes them much freer to do whatever they want to do. And a lot of arbitrators are very, very good. And you want to make sure you get a good arbitrator. But regardless, I think in arbitration, and if I'm defending, I would rather be in arbitration because I know I can just stretch it out longer. I can create more uncertainty. I can make a plaintiff want to settle a case better. On the other hand, mediation, I like. So mediation is non-binding. The mediator cannot force a certain agreement on you the way an arbitrator can. A mediation is kind of like the parties will meet in good faith, to try to resolve the dispute. I like that provision, and I like mediation because cases usually settle in mediation. Before you file for litigation, you must mediate. Before you file for arbitration, you must mediate. The parties got to get together. You're paying a mediator, usually a lawyer who's going to hear both sides, and they don't make a decision. They try to facilitate an agreement. Both sides are forced to draft position papers that explain their whole situation. It just kind of forces everybody to focus on the facts, focus on the issue, focus on the reality that this is going to go on for a long time and going to cost a lot of money. And, maybe it kind of makes sense to make a deal and move on. Most of the time, cases settle in mediation, and that's why I like it. I think arbitration makes it less likely cases will settle and makes it more likely cases will go to full trial. Litigation, people tend to, lawyers, you know where you're going to end up. You know what the contract says, you know what the law says, you know what a judge is going to do with it. And I'm telling you, client, I think chances are 70-30, this is where you end up. So you might as well just make that deal right now. It's more likely cases will settle. All right. So dispute resolution. Oh yeah, this is a good thing to put in any contract. Any dispute resolution or arbitration will not impact, negate, or delay any bond or mechanics lien rights. As a GC, you do not want any bond stuff in there in a subcontract. You do not. But a supplier or a sub does want it in there. That is generally the law, even if your contract doesn't say that. In other words, particularly with mechanics liens, most judges will rule that even if the dispute resolution procedure says you're going to have a good faith meeting and you're going to arbitrate or whatever it is, that does not impact your ability to file a mechanics lien. You can file your lien, then you may be stayed from enforcing your lien where you got to go do arbitration and then come back. That's the way most judges will rule. Bond is a little trickier, and it's a place things are changing. Courts are really split. The rule used to be that a arbitration provision or whatever it is didn't impact your bond rights, because the payment bond, the bond is just another contract, like a personal guarantee, like the AIA contract you have for the project. The bond's just another contract, and that contract doesn't say arbitrate. It's silent. That means litigation is the correct forum, and the surety must comply with their guarantee that they provided to the subs, to the suppliers. And that guarantee doesn't say anything about waiting till the arbitration's over. And I think that's the correct legal view. There are more and more courts that are ruling that everybody knows that the payment bond is connected to a construction contract, and the construction contract might have a arbitration provision in it. So, and it's collaterally stayed is one way you see it put sometimes. So anyway, so a GC would not want this provision we're looking at that says any bond. A GC wants to keep their bonding company out of it. And they don't, and a GC doesn't want mechanics liens filed either. But a creditor would, a GC in the general contract would want this sentence in there with the mechanics lien in there, even if they would not want the bond in there. A sub or a supplier would want both those things in there. All right, pay when paid. One thing I want to bring up is there's a difference between a pay when paid and a pay if paid. If what an AIA contract says, for example, it says GC will pay within 10 days of receipt of payment from the owner, AIA subcontract. The courts decided a long time ago in the 1960s, even before I started practicing law, the judges decided that does not create a condition precedent. The GC must still pay within a reasonable period of time. How long is a reasonable period of time? I don't know. But, by the time you file suit and get to court, it's been 6 months after the project's done. A reasonable time has passed by then. So that's never a problem, the reasonable time requirement. What the courts ruled in those cases is that if the parties wanted to make payment, receipt of payment from the owner, a condition precedent to the GC's obligation to pay, they could have said so in the contract. They didn't. Therefore, the owner must still pay within a reasonable period of time. So then all us lawyers, when we heard that, we went rushing out of the courthouse. We went back to our offices and we revised all our contract forms so that they now all say it is an absolute condition precedent to the obligation to pay sub that GC actually received payment from the owner. And you will usually see these words, condition precedent, in there. That's the clearest way to make a pay if paid clear. And that does mean what it says. In other words, there's simply no obligation on the GC to pay unless and until they receive payment from the owner. You're usually looking for the words condition precedent. It is possible to write one without those words, but it's harder. In other words, you could say the GC has absolutely no obligation to pay the supplier unless and until they actually receive payment from the owner. The words condition precedent aren't in there, but that probably gets you there. That's pretty clear. All right. The AIA contract forms are a pay when paid. That it doesn't really concern you as a sub or a supplier. That's one of the reasons you like AIA contracts. You also like the right to ask for evidence of funding, et cetera. Okay, we did that. Okay, reduction in retention. If you think retention is going to be reduced at substantial completion, you need to say so in the contract. It is not an automatic. A lot of people don't understand that. And if you, as a sub or a supplier, if you think your retention is going to be reduced when the GC's retention is reduced, you need to say so. It needs to, otherwise the GC doesn't have to reduce your retention. It's not in the subcontract. You need to say subs retention or suppliers retention shall be reduced in the same manner and at the same time as the retention of buyer is reduced. That's patently reasonable. You can get people to agree to that, but you must put it in the contract. Okay, here's your highlights. Boy, our timing's coming out great. We have 120 seconds until 12 noon and we're at the end. Have your own addendums available? Yes, we do have slides. I can email this to you. It's a 2-page, I think it's 8.5 by 11, 2 pages. That I can email, and you can copy and paste. It's a good checklist of things you may want to add. You can copy and paste parts and put it into a document you're reviewing, or you can just print it off, fill in the blanks, print it off, and attach it. And I can send you guys this PowerPoint if you want it. Please look, let me know if you want a hard copy of the book. And you can look at the book on the website anytime you want. Okay, so here's your highlights. Reviewing contracts received from others. Add notice and opportunity to cure is probably the single biggest. Eliminate bond and lien and bond waiver is not as important as it used to be. Add a definite schedule. Delete the right to unilateral changes in the schedule. Add an interest and attorney's fees. Single biggest leverage thing. It works me out of a job. It motivates people to settle cases. Add the right to get funding information. Add limitation. This is one thing we didn't talk about because it's kind of lawyerish, but you want to add your limits to liability. In other words, I can't be liable for any more than giving you your money back is an example of that. That's a good provision to add. I suppose I ought to do slides of that. Forum selection. Add the right to stop work on non-payment. Slides on limitation of liability. Slide. All right. Add a trust fund provision. It doesn't hurt anybody. There you go. There's the website. I enjoyed it. I will hang around for a few questions. Hopefully I'm smart enough to undo the muting. Let's see, mute. Mutes me, participants, security. Okay, you're now all allowed to unmute yourselves, I think. If you want to. You were always allowed to chat, it looks like. I'll let you slide your screen. Anybody got anything? Just unmute yourself and speak up, or send me a chat, either way you like it. Hello, Rod Morgan. Have you really been here the whole time? What? Oh. Where's let me find Rod Morgan. Maybe I do have to ask you to unmute. I thought I did that, but there you go. There's your, I'll ask all of you to unmute.
I'm checking to see if it works. I really don't have much to say for a change.
Well, no, I'm glad to have an opportunity to see how this works, because we're learning together how this works. So yeah, I unchecked something on under security. I said allow participants to unmute themselves. I did that, but it looks like I have to actually ask you to unmute yourself. So I'll ask everybody to do that. Yeah, I knew something was wrong because there were so many people still here. They hadn't left yet, but I wasn't hearing anything either. So boy, Rod, you sat through that whole thing for about the 45th time in your life.
Jim, you have some messages in your chat box too.
Okay. Oh, yes, I have a lot of very gracious messages. I didn't see a particular question other than Rod's statement that he can't unmute. But yes, I'm getting very gracious comments, and I'm glad everybody liked it. Yep. So March the 9th, which is FYI, the day after my birthday, which is irrelevant, except I'm getting older. So thank you all for attending. All of you should feel free to email me a question anytime you want, or give me a call. And I'll look forward to seeing you on March the 9th, if not before.
Thanks so much, Jim.
Okay, bye.
Bye.